I'm here in the Ontario Appeal Court, am I correct?
The Ontario Court of Appeal, that's right.
Okay, thank you very much, because I'm not a lawyer, so the legal speak is not my forte. So you are legal counsel representing the JCCF, the Justice Center for Constitutional Freedom.
Basically, my name is James Manson. I'm legal counsel with, we're affiliated with the Justice Center, that's correct. I'm acting for some of the defendants in the big class action that's happening in Ottawa right now. This is the one where a lot of downtown Ottawa residents have decided to sue many of the protesters, the truckers, the donors, and the organizing people for about $300 million because of what happened during the Freedom Convoy protest. So we're here at the Ontario Court of Appeal today. We just finished an appeal before the Court of Appeal. It's an important mechanism. What that is where we're trying to suggest to the Ontario Court of Appeal, that's the highest court in Ontario, that a decision made by the case management judge, that's Justice McLeod in Ottawa, he's handling this case, was incorrect, that there were some mistakes made by the judge. The actual decision is kind of a procedural decision. It's about whether or not the case ought to be dismissed kind of on a preliminary basis because of a certain list of factors. And this all comes from whether or not you can say that the actual lawsuit that these people have set up against the protesters, whether that action is based on public expression, basically, on expression based on a matter of public interest. And we say that it was. And I think that it's fairly clear to suggest that it was. Now anyway, this mechanism that I'm talking about is kind of technical and pretty complicated, and basically what it does is it asks the plaintiffs to start to prove in a very, very high level basis that their claim is worth going ahead, that they have enough evidence and that they have enough legal arguments to justify going ahead. Our position was that they don't, was that they have not enough evidence. They didn't prove a certain couple of things that are required to prove in order for them to get what they're seeking. Particularly, they're asking for the court to award damages of about $300 million for the idea of public nuisance. And the public nuisance requires you to have a special and unique kind of damage that is over and beyond everybody else in the same neighborhood. We suggest that the plaintiffs haven't been able to show that. So anyway, that was largely what the case was about today. The judges did not make their decision. They've taken the case under advisement. So we'll see what happens. But I do think we've given them a lot to think about. And hopefully we can get a good result for our clients. If not, this will not end the case. This will probably take us forward to further motions and further appeals before we get to the trial, which could still be quite a ways away. So stay tuned for further developments.
Well, I appreciate you talking with us, and thank you very much.
Cheers.
I did sit in the court and was very impressed with it all, so thanks, Mr. Wilson.
All right, thank you.
All righty, thanks very
Bye-bye.
much. Bye-bye.